Thanks everyone for joining this first committee meeting of the Committee on Rulemaking to consider the draft recommendation on temporary rules. I'm Ben Burkhill. I'm an attorney advisor with the Administrative Conference of the United States. We're going to start by turning things over to ACUS Research Director Jeremy Grayboys, who's going to provide a few brief opening remarks. Jeremy.
Thanks, Ben, and I will be brief. So, as many of you recall, this project grew out of a recent project on public participation in agency rulemaking under the good conduct exemption. Temporary rules were identified as a related but separate topic that warranted additional study by the conference. My colleague Eyal Luri Pardes stepped up to conduct the study for the project, and he's done a truly wonderful job. If you haven't read it, he's prepared an exceptional report that is a fascinating read, in addition to serving as a useful tool for this committee and the conference in developing a recommendation on this important topic. Thanks also to public member Jennifer Dickey for chairing this committee. This is her first time chairing a committee project, and to Ben Burkhill for not only serving as staff counsel, but working with Eyal and me to develop not only a report, but the recommendation you'll be reviewing today. So thank you all for being here.
All right, thanks, Jeremy. We will next do the roll. So I'm going to call two rolls. The first is going to be the names of committee members and their alternates. After each name is called, the person should say here so we can make sure their mics are working. The second roll will be the names of ACUS members who are not on the committee and their alternates. After each name is called, the person should say here so we can make sure their mics are working. I will not call the names of members of the public who do not have speaking privileges. All right, so we'll start with committee members. I see Jennifer B. Dickey, so we're good.
Here.
Thanks. Is Larry Allen here? All right, how about Laura Barheit? I think I saw Tyler Badgley.
Here.
Right. Amy Bunk.
Here.
Thank you. Stephanie Davis, I think I saw.
Here.
Great. Andrew Emery.
Here.
Great. I saw Bill Funk.
Here.
Great. Alex Goodenough.
Here.
Elizabeth McFadden. Nope. I think I saw Nina Mendelson.
Here.
Thank you. Elena Ness.
Oh, yes, I'm here. Good afternoon.
Thanks. Is Mitch Plave here? No. David Pritzker. I saw Lon Smith.
Here.
Right. Tony Verona.
Here. Good morning from the West Coast.
Hi, good morning. I'm glad we could do this in the afternoon.
Yes, thank you. Thank
you. I saw Miriam Vincent.
Here.
Thanks. David Zaring.
Here.
Thanks. Are there any committee members whose names I did not call?
Jessica Stone is here.
Oh, thanks, Jessica. Anybody else who's on the committee? Okay, I'll go to non-committee members. Devin Frey, alternate for Dan Cohen.
Here.
Awesome. Jeff Lubbers.
Here.
Do we have anybody from Department of Justice, Christina Greer or Bob Hinchman? Okay. Tom Johnson.
I'm here.
Great. Steph Tatham.
I'm here. Thanks.
Thanks. Is there anybody who's a ACUS member who's not on the committee whose name I did not call?
This is Brigham Bowen. I thought I was on the committee, but I can't.
Oh, yeah, you are. Maybe I missed you. Sorry. Thanks, Brigham. I got you.
This is Bob Hinchman from Justice. I'm on, but I couldn't find the unmute button fast enough.
That's okay. Okay, we got you now. Thank you. Anybody else who is not on the committee, but is an ACUS member and whose name I did not call? All right. Anybody else that I missed just that's on the committee? Any late joiners? Nope.
I'm not on the
Okay.
committee. I work for Legal Services Corporation. I have been shadowing Stephanie. I'm Brittany. I'm Assistant General Counsel in the Office of Legal Affairs. I was
yep.
invited as her guest as I'm learning more about this.
All right. Yeah. Yeah. Thanks, Brittany. Yeah, we got you.
Okay.
I talked to Stephanie about
Sorry,
that.
I was late.
Thank
Thank you.
you. No, that's okay. Thanks. All right. I'm going to turn it over to the committee chair, Jen Dickey. Jen.
Great. Good afternoon, everyone. I'm excited to work with you all on this project and to work with this committee, which I don't believe I've worked with before in my time on ACUS. So standard rules for the committee applies. This means that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation if possible. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature because we can't capture them on the recording as well. Only members of the Committee on Rulemaking, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. Does anyone need clarification now as to whether they are a committee member or someone who has speaking privileges or voting privileges? Seeing no questions, I'm going to go ahead and turn it over to the in-house researcher, Ayal Luri Pardez. He's going to give a short high-level overview of the report.
Hi, everyone. Thank you, Jen. I hope everybody can hear me. Yes? Perfect. So I'm Ayal Luri Pardez, and I'm attorney advisor here at ACUS, and have been working on this report on temporary rules for the past year. And this has been much a collaborative effort, as Jeremy mentioned. I really want to thank him and Ben who provided incredible guidance, and to any ACUS member and agency officials who offered insights at various stages of this project. The report was developed to identify best practices for how agencies use temporary rules. We wanted to understand, when do agencies use them, what factors guide those decisions, and how do agencies engage with the public in the process. Our methodology combines several approaches: a review of the historical and doctrinal foundations of temporary rulemaking, interviews with agency officials, 7 case studies, a search in the Federal Register, and finally a survey of statutory provisions authorizing temporary rules across all 50 states. I'll try to keep my remarks today short and focus on a few main takeaways from the report that might help guide today's discussion. First, a key threshold issue for the study was definition. For the purposes of this report, we define temporary rules as legislative rules that include an expiration date, whether that date is a specified calendar date or conditioned upon a future event. The essential point is that such rules expire unless the agency affirmatively acts to extend them, make them permanent, or repeal them. While this definition is broader than traditional uses of the term, we adopted it because all of the rules captured by it share an underlying feature. They allow the agency to effectively undertake 2 regulatory actions in one. They both promulgate a rule and repealing it at the same time. This dual action requires the agency to provide not only a reasoned explanation for the substance of the rule, but also for its limited duration. Based on this definition, we identified 3 main categories of temporary rules. The first are regulatory deviations, adopted when agencies need to depart from their ordinary regulatory framework, whether in emergency or non-emergency context. And extensive use of temporary rules during the COVID pandemic could provide a recent illustration of that category. Another category are temporary rules issued for the purpose of regulatory learning. And this category can include periodic rules, rules that facilitate pilot programs, and rules with sunset clauses used to mandate retrospective review. And the third and last category involves adjustments to legal change, typically issued during transitional periods following statutory amendments or judicial rulings, when agencies need to provide interim guidance until a more permanent regulatory structure is in place. I think the report's finding can be largely organized into two buckets, to two critical junctions in the life cycle of a temporary rule. The first junction concerns the agency's initial decision to employ temporary rulemaking. This phase raises questions such as what is the appropriate duration of rule, the structure and timeline for public participation, and the availability of alternative regulatory mechanisms that could potentially achieve similar policy objectives. Furthermore, at this stage, the agency needs to determine what type of rule document to submit to the Office of the Federal Register, particularly whether to use the process that allows OFR to automatically remove the rule from the CFR upon expiration. The second junction arises at the point of expiration. It includes how agencies prepare for the expiration date, the procedure for extending temporary rules, how agencies should evaluate the temporary rules' effectiveness, especially in the context of regulatory learning, and how agencies ensure that the rule's termination or continuation is accurately reflected in the CFR. This is just a few short remarks that I made now, but I look forward for today's discussion in the committee, and I welcome any questions. And please reach out if you have any additional thoughts or suggestions on the report itself and not just the recommendation. It is still a draft report, and I would appreciate your help in finalizing it. And with this, I'll turn it over to Jen.
Great, thanks, Eyal. And I know, at least for me, I thought it was a very interesting report, very well done. So good job to you. Now I think it's time to turn to the recommendation. Typically, I have found it most useful to start with the actual recommendation portion, the at the bottom. And once we agree on that, then we can make similar changes to the preamble if there are similar parts in the preamble. But I've just found that in the other committees I've been on to be the most efficient way of going about this. So that's what I think we're going to do here. I guess before we kick it off with specifically walking through, I want to see if anyone has high-level remarks or concerns about or things we should talk about that are kind of overarching concerns before we dig into the first paragraph. I see Bill Funk has his hand raised.
Thank you, and I did enjoyed the report. My sort of big picture questions were, one is Ron Levin's comment regarding coverage of the report, and I would have my initial thought would be to support the idea that it would be broader than what is defined currently as a temporary rule, to include with the things that Ron Levin mentions, because I don't see that it would change anything substantively. And I'd ask Eyal to respond to that. That's one point. The second point is, it seemed to me that the importance, the critical agency that's involved here is the Office of Federal Register. And yet we have no recommendation regarding the Office of Federal Register. And I thought that that at least one particular thing I thought would be worth recommending would be what Eyal suggested in his report was happening anyway, but I don't know if it's what the status of it is, which is to include temporary rules in the rulemaking part of the e-Federal Register. And that would seem to be a very important consideration. But there may be other aspects that I think that maybe the Office of Federal Register could be a good source of guidance to the agencies in a way to help further the recommendations that we might make here. So I just thought that it didn't seem that any of the recommendations were really addressed to the Office of Federal Register, and I thought we should think about that. And then I'll leave it at that for this time. So Io, could you respond to Ron Levin's comment?
Yeah, sure. I think Ben can, you can say if you have any additional thoughts after writing the recommendation itself. I don't think I have any objections to his comment. I think that we wanted to not include interpretive rules and rules that don't have a general applicability of the law. But if we wanted to have a more broad category, I think that it definitely aligns with the report's intention. We tried, I think the reason for the original language was that we tried to identify specific rules that use those exemptions before we include them as part of our definition. And I don't remember coming across, for example, temporary rules that invoke the procedural rule exception. There might potentially some rules that we missed. There are thousands of temporary rules, and I don't think there's theoretical contradiction.
Can I just respond? It's not just the procedural rules, it's also the rules of agency contracts and grants, the general exception for those kinds of rules that, for the most part, agencies have gone through notice and comment, even though they weren't required to by the APA, in some cases because they adopted internal rules saying they were going to do that. But some of those internal rules have been rescinded. So the idea that rules involving grants and contracts don't have to go through notice and comment anymore, but nevertheless, I think we would want them covered as part of this process.
So as to the scope, I don't have an objection to Ron Levin and Bill Funk's seconded suggestion. I see that we've already scrolled up to footnote 1 being like a proposed amendment. Do other people want to speak about this particular issue? I saw a hand raised by Miriam Vincent earlier, and now I see Nina Mendelson. Are your comments about this particular issue? If so, we'd love to hear from you. Miriam can go first. If it's not about this issue, then maybe Nina, if it's about this issue.
My comment was not specifically about this issue, so go.
Okay.
Rulemaking.
I'll put you in the queue then. So I guess let's start with just, does anyone have any objection to Ron Levin and Bill Funk's suggestion about defining it more broadly to be rules as defined in the Administrative Procedure Act, except that it does not address interpretive rules and general statements of policy, the text we're seeing here in footnote 1? Any objections to that suggested edit? Okay. Hearing none, I guess we'll just take a voice vote in favor of adding it. All in favor, please say aye.
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 And then the second comment that Bill raised, Ayel, did you have a thought about the second question he raised about including a recommendation for the Office of Federal Register to include temporary federal rules in the electronic register? That's not currently happening. Is that correct?
I think Miriam might have can talk more about exactly the differentiation about what is represented in the ECFR and what's presented compared to the CFR. I'm not sure if we need necessarily our recommendations directed to OFR. I think we can, a lot of the ideas that we have here, we can then work to implement them and see what fits rightly with the agency and what is not. But I'm happy to hear the committee's thought on that. I don't know if Ben or Jeremy have anything to add on that particular issue.
Okay, my apologies. It looks like Nina said in the chat that her comment related to footnote 1. Nina, did you want to come off mute and make the comment on that? I apologize.
Okay. Okay, yes. I think the amendment is fine, but given that, actually, maybe the amendment's fine. I was going to suggest adding the additional clarification that The rules specifically called out in 553A2, agency management personnel, public property loans, grants, benefits, or contracts, that we should actually add specifically that those are included by this, or that those are covered by this recommendation.
And would you suggest doing that
So-
by adding text or by adding a citation in the 5
or
USC
just
550?
just adding text at the end of the sentence. Others may think it's unnecessary. I think it might be helpful clarification because those rules are not generally subject to, because those rules are not subject to what we think of as the core requirements of 553. And so many agencies may wonder if they are then also subject to the temporary rules recommendations that we're making here.
Do you have some language you would propose that they can type in?
Yeah, I can propose some language in the chat if that's the best way to do it. But maybe you want to hear from others on whether they think this is even necessary.
Sure. So I see Lon Smith has his hand up. Is that related to this issue? If so, please go ahead.
Yeah, yes, the question I have is, if the IRS issues a temporary regulation that's an interpretive regulation, is it subject to this? Because it's going to be accompanied, it has to be accompanied by a proposed regulation, which is going for notice and comment.
I think the answer is no, as currently written, because it says it does not address interpretive rules.
Right. Is everybody happy with that rule? Because the IRS is going to believe that very few of its temporary regulations will be subject to it.
If I can jump in here, I think just based on my research, many of the temporary regulation of the IRS, they're invoking different clauses in the APA related to the notice and comment. Not all of them necessarily interpretive rules. Interpretive rules, and I think that generally, with a policy statement from 2019, they do follow some sort of a good cause justification in the regulatory text, in the rule document that they submitted to the OFR. So I'm not sure if that answer your concerns or not. But I think it's a very specific case of a temporary regulation under statute, and I'm not sure if it won't be captured even by the current text.
Again, I'm not opposed to it. I just the IRS, the folks at the IRS are going to tell you that most of the regulations are interpretive regulations, and so when they look at this, they're going to say, "You don't have to follow it," even though the temporary regulation, everyone goes out for notice and comment, has to by statute. And is everybody okay with that? I know you obviously looked at the IRS, and he was the first example that you mentioned in your report. They'll be happy with what you're doing, but they're going to say it doesn't apply to most of the regulations. Although if I were there, I would apply it anyway because it's a good practice. But
okay, so Nina Mendelson put potential additional language in the chat, so I'm going to read it out loud so that that Ben can add it to the footnote one. It says, however, this recommendation does apply to all rules described in 5 USC 553A, such as rules relating to management, personnel, public property, loans, grants, benefits, or contracts. And you have an extra period now left right after policy, yes. Does anyone have reaction specifically to that language Miriam, you've had your hand up for a while, so.
No, I don't have a problem with that language. I've got my hand up for some other things, sorry.
Okay. Well, with respect to this language, does anyone have any concerns about this language proposed or want to speak to the Nina Mendelsohn amendment, as we will call it?
Looks like Bill and Jeff both had their hands up physically and virtually.
Oh, I can't see it. Sorry.
I don't know if they're
I only
frozen.
see
They look
two.
almost frozen.
Okay, Bill, go ahead, and then
Well, what about military and foreign affairs? That's also in 553A, and it's not called out as such. And again, we do want procedural rules, which would be included in this, but they're accepted somewhere else.
Oh, true.
So
I have a suggestion.
Jeff.
Yeah, I agree with Bill. That's one of the points I was going to make. I think we can just say, so I don't really think it's necessary to specify all these things. I think we could say, as defined in the Administrative Procedure Act, and then put in 5 U.S.C. Section 551(4), period. I mean, not period, but that would take care of the need to add all these other specifications. That's the way I would handle the point that Nina's raising. But I also want to address the point that Lon's raising, because I think it's a good point. And I think that we should, after we put in the citation to 551(4), where the cursor is there, I think we should say, except that the recommendation does not address rules that have been issued pursuant to the interpretive rules and general statement of policy exception, or rules pursuant to the exception for interpretive rules and general statements of policy. I think that would help address what Lon is saying, or does not address rules that have does not address.
Let me see if I can phrase what I think you're saying,
Yeah.
Jeff, which is it wouldn't apply to rules where the agency is invoking the exception.
Yeah.
The exception for
From notice and
interpretive
comment. From notice and comment.
And so therefore, even though something might be an interpretive rule, but if they're not invoking that exception from notice and comment, then it would be covered by this.
Right,
so
because lots of legislative rules also are interpretive rules.
Sure. Yeah.
Typically, I think we don't tie it, typically, at least in recommendations I've seen, we don't tie it to whether the agency invokes it, but whether it like actually is an interpretive rule, out of concern that, sometimes an agency might improperly invoke an exception to notice and comment rulemaking or the like. So,
well, that may be, but I don't think that's applicable here, because if they're going to wrongly invoke an interpretive rule exception, then we have a different problem involved. All right. It's not the problem with this particular series of recommendations. So I think Jeff's idea is terrific, which I think would take care of all the problems.
So just to go back to the first line of footnote 1, that would say it applies to rules as defined in section 551(4) of the Administrative Procedure Act. Okay, that takes care of, I think, now we don't need the however sentence in at least the way I look at it. And then we deal with the language that Bill just.
Except that the recommendation does not address rules and general statements of policy.
Interpretive rules and general.
Interpretive rules and general statements of policy. when an agency invokes the exception to notice and comment.
Does not
Is that-
address rules for which the agency has invoked the exception from notice and comment for interpretive rules and general statements of policy.
Terrific. Yeah, yeah.
We can
And then
massage
you
that
can,
language.
you can take out everything after that, I think.
That's different from the proposal, because like originally, I think the text included rules for which they adopted, with a good cause exception, like that they were included in the scope. So, and this is actually narrower.
Well, no, they're still covered.
No, because you're saying except that the recommendation does not address rules for which the agency has invoked the
Exception for interpretive rules and general statements of policy, not the exception for good cause.
Right.
I thought Jeff was talking about the good cause. So
No.
Nina,
Yeah.
Nina, are you comfortable with this? Because it's
Yes.
relying on the
This is a
same
I would
551
consider
for
this
definition.
a helpful and friendly amendment. However, I have a question about it, which is why exactly doesn't this recommendation, I can see why the recommendation doesn't cover interpretive rules, but why doesn't it cover general statements of policy? Couldn't general statements of policy sometimes be temporary policies? And if so, wouldn't we want the agency to specify in advance when it thinks it might reconsider those? But yes, fine to delete the sentence that says however at this point.
Okay. Eyal, did you want to respond to why we're not including interpretive rules and general statements of policy?
It's a question for Ron Levin.
They were always accepted. Ron didn't take issue with that.
Yeah, that's how it was originally drafted. Eyal,
I
did
can
you have a
also,
thought?
I think I also want to add that we need to scope this project into something. I think there are a different set of consideration of using other regulatory tools that are not legislative rules with the effect of the law. And I think this is just the way to scope it. There is some relevance to temporary guidance and general statements of policy, but I think we do not address this. I did not do the same amount of research and comparative analysis of how different agencies use those tools. So I think it's hard for me to make recommendations on those instances just for the scope of this report.
So I couldn't hear you clearly, but I'm understanding you to say basically this is an artifact of the scope of this project and the amount of research that you did rather than some kind of principled distinction between, temporary general policy statements and temporary rules.
I think so. Maybe Jeremy and Ben can jump in if they have more space.
Yeah, I can jump in. I don't think it's excluded from the scope of the project. I mean, certainly if the committee thinks that these recommendations are applicable to all rules as defined in 551, then the committee should say so. I think our concern was rules is a somewhat clunkily defined term in the APA that could include a wide variety of things. I mean, perhaps it includes staff instructions, administrative manuals, and at a certain point, we were looking for some principled way to say, this is a set of best practices that apply to those most important, what we're talking is sort of paradigmatic rules, regulations, and carve off more informal stuff. Tying it to these categories in 553 maybe is not the right approach, but the idea was to carve off more informal agency statements that may be technically rules under 551.
Does anyone have a reaction to that? My one reaction is looking at some of the recommendations. Some of it doesn't seem as applicable to an interpretive rule or policy guidance.
Yeah, that was my reaction too, because a lot of the Federal Register things wouldn't necessarily apply to guidance documents that don't have to be published in the Federal Register or sometimes are not published in the Federal Register.
Yeah, so I guess I'm comfortable with leaving them out of the scope of the recommendation, but Nina, what do you think?
I think it's tough, actually. I mean, clearly part of this is aimed at publication practices in the Federal Register that will make what the agency is doing more transparent to the public. And also giving the public notice, like this is temporary and here's what we're going to do to reconsider it. Both of those could apply to a significant number of policy statements. And the reason why I thought maybe interpretive rules were different is just because interpretive rules don't tend to be temporary, but that's really an empirical question. So I guess I'll take it back to IL, and maybe you haven't looked at this specifically, but basically, I don't, what's the reason for exempting them? Why not simply just leave them in and let the agency assess, does this recommendation seem to apply?
So
I think someone might need to mute
I think it's a hard
themselves.
question from the way that I looked at it. I think Jeremy and Ben might have a different opinion. The way that I looked at it is that I was looking mostly at the legislative rules with respect to the law, and I use other regulatory tools. I think guidance documents is an example that sometimes agencies employ those type of regulatory tools instead of temporary rules when that is an option, a legal option. But I did not. I think it's just it's a different phenomenon from my understanding. I think there definitely an overlap in the recommendation, and they might be helpful. But I'm just have not looked at it. I look at it just as an option of an alternative, and not as a kind of a comparative example that I can provide to the committee. If you find more of this in the report, then maybe we can consider that. That is my intuition. I looked at it as an alternative to consider. I think we have several times in the recommendation that we say that agencies can consider other regulatory tools if they're applicable, but I'm not sure that all recommendations are on point with the interpretive rules.
I can just add something.
Jeremy?
Go ahead.
Yeah, I was just going to say a middle ground possibly is instead of saying this includes ABC and doesn't include DEF, is to say this includes this set of rules and agencies should consider how they're applicable to other categories of rules. So it may be that some of these recommendations are applicable to interpretive rules, the statements of policy. You don't have to say the recommendation doesn't apply to them at all. And I think there's probably language in earlier recommendations. I think we did one on recusal years ago. We said this applies to ALJs, for example. And while it doesn't necessarily apply to agency heads may wish to consider whether it's appropriate. So I think a similar approach might work here, which is to say, consider in your own circumstances whether it applies to interpretive rules and policy statements, but don't actually say it does or does not apply in toto.
Okay, Jeff?
Yeah, I think it doesn't really apply that much to to guidance documents, because agencies can change their guidance documents whenever they want. You know, it's not like a rule that's been published as a through notice and comment that has some real binding impact on the public. They need to know when that's going to expire. But a guidance document, an agency can change it on a dime if it wants to. So I don't really see many concerns about temporary guidance documents, and that it's pretty hard to regularize that anyway. So I think it's fine the way it is.
Nina?
Yeah, I really like Jeremy's proposal. I think that's a smooth way to handle it, and an agency can certainly change interpretive rules and general policy statements easily, but it can also change all those other exempt rules as well very easily because it doesn't have to go through notice and comment. So I think agencies, should consider whether these apply in these other categories. Seems like a very, very reasonable outcome. And of course, general policy statements are known for changing people's conduct, even if they don't formally have the force of law.
Okay, so what I'm gonna do is suggest that Ben and Jeremy find that proposed language and let's put it back in and put a pin in it, come back to it once we have sort of a similar proposal from maybe the recusal rule you suggested, and then we can vote on that. But that way we can move on to some of the other matters. Sorry, Bill. Do you have
Right.
a comment on that?
I think that's fine. I just would note, we're talking here about the preamble, right, to the recommendation, which would be a particularly appropriate place to put the language that Jeremy was suggesting, rather than in the recommendation itself when we get to that point.
Right. I think that's where it would go, in that like footnote 1. Miriam?
Yeah, I had a handful of sort of overall comments that both from the draft report and from the recommendations. Reading the draft report, it sounds like there's a special way to submit these temporary rules, a special submission track. And there's not. These rules, temporary rules, come in just like any other rule. There's a specific way of drafting them, and then after they're published, we take extra steps to handle them because they have an expiration date. But that's the extent of them being special. So, and I've got some language to recommend to IAL in terms of tweaking the the draft report to make this more clear, that it's not that these are like any kind of special handling type of thing. It's all in the drafting, and it's not in how we handle them or how the agency gives us these documents. If the sense of the committee is to add extra recommendations for OFR, you know, we're certainly willing to take recommendations and to look into them. We are currently working on a process and procedures to figure out already which temporary rules that are not currently codified and appearing in the print CFR will go up online into the electronic CFR. So that's something that we were working on before the end of last year. And we now have perhaps greater flexibility looking forward with the passage of the Federal Register Modernization Act. Although with everything that's been going on this year and with our own executive order, we have not had time to focus on a lot of what the new statute means for us and for our processing. But we are cognizant of the fact that there are these temporary rules that don't appear anywhere other than the Federal Register, that we do want to get into or online into the ECFR. And so that is something that we are already trying to figure out, what that line is between more than 3 days, being effective more than 3 days after publication and fewer than 12 months after publication, to get them into or codified so that the public can see them as part of a codification.
Okay. That's super helpful. And it's great to hear that you're working on that. Amy.
Yeah, hi, Amy Bunk, Senior Fellow. Related to that idea of offering some suggestions to OFR on temporary rules, I think the report and the recommendation kind of hints at some of the agency's difficulties, the idea that authority sites might disappear if agencies try to amend those in a temporary rule. I think the other important issue for us staff at agencies is to, if you're going to extend the temporary rule, to make sure that you publish the document before the new rule, before the temporary rule expires. And so I pulled up the OFR's document drafting handbook. Sorry, Miriam. And maybe they can extend their temporary rules section to kind of explain some of those pitfalls and maybe add some best practices for agencies. So that would be my overall suggestion. Maybe highlight those kind of issues for agencies in the recommendation a bit more.
Okay, so it sounds like we have 2 recommendations on the table to add to the recommendation list directed to OFR. The first being Bill's suggestion that temporary Federal Register rules should appear in the Federal Register, the ECFR. Like we could probably put that, phrased as like OFR should work on a procedure to make temporary rules available in the electronic Federal Register, something like that, which we know that they're already doing. But like it would be great, and maybe it would be helpful to OFR for us to put that in the recommendation. And then the second is the recommendation from Amy that OFR should also amend its guidelines for drafting rules to clearly to provide best practices for agencies to ensure that they submit in time to have a new rule before it expires, and best practices for agencies using temporary federal rules, including how to submit in time to make sure that it is that a new rule comes in before it's expired, or something along those lines. Those were the 2 recommendations I heard on the table for OFR, both of which seem like good ideas to me, at least in principle. Bill, I see you have your hand up. Do you want to add something on those 2 points?
I think you've captured them both very well, and I would just say I don't think we should spend time in today's meeting on that, but send it back to the guys who'd really do all the work at ACUS to come up with some language that we could consider next time. That's my recommendation.
I agree with that. Elena?
I just want to note that some temporary rules do already appear in the ECFR. Miriam will probably know the specific criteria. I think there's a certain duration that applies when they do appear in the ECFR, but we have many temporary rules listed in the ECFR.
Yeah, so the part of this, it's not always obvious because it is based in great part on whether the temporary rule is in effect as of the date of revision of the print volume that they appear in. And since the print CFR, the annual revision, is on a rolling basis, some are revised as of January 1, some April 1, some June 1 or July 1, some October 1. So if the temporary rule would normally go like for EPA, let's say, or Coast Guard, if it's a Title 33 that would be a July 1 book. But if it's a Title 49, that would be an October 1 book. So if the temporary rule is in effect as of July 1, it would be codified and it would appear in print in the July 1 book. But if a similar temporary rule published at the same time would be codified in the Title 49 regs, and they expired before October 1, then they would not appear if they were of a duration of less than 12 months, because they were not in effect either the October 1 before or the October 1 after, so they were never captured to be printed. So some appear in the print, and if they appear in the print, then they would also appear in the ECFR. But if they're not going to appear in the print, that's what we were before the Federal Register Modernization Act, trying to figure out how we capture those temporary rules that are more than probably 3 months, but less than 12 months, that would not actually end up in the print book. With the Federal Register Modernization Act, we have potentially more latitude to expand and not be completely tied to print, but we don't know really what that means. We have not explored that. So that's something that we're going to be looking at for a lot of our publications going forward. But we still, everything right now is tied to the print, and uncoupling from the print, it means we don't necessarily know what that means. I mean, that's a huge system change. So whether that's, I mean, it's going to cost money, how much money, what all of that means, we have no idea. 10 years from now, I think everything is going to look completely different. Next year, I think everything's going to look exactly the same. So, it's going to be a transition. We got to figure out what we can do, what we're permitted to do. Oh, do some visioning, figure out, since now all of a sudden we do not have to print everything necessarily the way that we have been going for the last 90 years, basically. So we will see what happens. But yes, so it can be confusing because some temporary rules are codified and some aren't. And a lot of that codification depends on if they are actually in effect when the CFR volume is revised.
Okay, thank you. Bill, did you have something quickly on this point? If not, I think we're going to move on to the.
I have a question for Miriam, just to make sure I understand what she was saying. If something is in the ECFR, it will be in the print CFR. Is that correct?
As of right now, yes.
Okay, that's all I needed to know.
Okay, so let's turn back to the recommendation. And I know we have a comment from Senior Fellow Michael Hertz. It seems that specifying an expiration date for a rule and promulgating a temporary rule are synonyms. Likewise, temporary rule and a rule containing an expiration date. If so, it would be clearer to pick one and stick with it. My vote would be for temporary rule. If not, the difference should be explained. Miriam, I see you have your hand raised.
So, we do have agencies that publish rules with expiration dates that they do not consider to be temporary in the sense that we're discussing here. Whether ACUS wants to consider them temporary or not we can discuss. But if I mean, we've had instances where Congress creates a program for a specific duration of, say, 5 or 6 years. So the agency promulgates regulations for that length of time. So there's an expiration because the regulations can't outlast the program, or they can't outlast if Congress says you only have authority for this long to do something. So in that sense, they're temporary, but the substance of the regulations, they're permanent for the life of the program. So the agency does not consider the regulations temporary. The authority that they have, or the program, exists only for a specific amount of time. Or in other cases, Congress decides to eliminate an agency. That agency has regulations on the books. So if the agency is eliminated without removing the regulations, then we have a situation like we had with the Panama Canal Commission, which disappeared and left the regulations in place. There was nobody in existence to remove those regulations. And so we had Panama Canal regulations for about 25 years until the Office of the Federal Register and the director decided, okay, yes, that commission is gone. The regulations are in fact defunct. So we're gonna, under orderly codification and some other authority, we're gonna say, yes, I have the ability to remove those regulations. But that's an extraordinary circumstance. What we really encourage agencies that know that they have basically a sunset date is to then publish a rule with an expiration date that says, okay, as of the date that we disappear, our regulations disappear as well, so that the regulations aren't on the books after the agency is no more. The regulations were on there. They weren't temporary. Those regulations had been on the books possibly for decades. There was no change to the regulation. The rule that was published made no change to the text of the regulation. All it did, or it may have had a change, and then, had then said, okay, and as of this date, everything goes. So, I mean, there are different times agencies have expiration dates when that expiration date is not considered as part of a temporary rule. But for the purposes of this recommendation, if you want to consider everything with an expiration date as being temporary, to make it easier.
I think the best thing is to limit it to things where the agency is like contemplating the expiration date at a very specific time at the outset, like not like just like some of the examples you use where it is temporary because the commission ends up expiring. That strikes me as like different and not what we're really focused on here. I think my instinct is that currently it makes sense that like the first recommendation about determining when to specify an expiration date is kind of just like thinking of, I mean, I guess you could say determining whether to use a temporary rule, but you can also focus on the this like specific thing, and then we use temporary rules after that. That makes sense to me. So I was fine with it as written. Bill, I see you have your hand raised. What are your thoughts?
I mean, I'm going to go back to addressing Michael Hertz's pressing suggestion question. And I just saw that it's a different issue. You could say determining when to issue a temporary rule as opposed to when to specify an expiration date. But specifying expiration date seems to me you're actually specifying a specific date, all right? And there are temporary rules when there is no specific expiration date because you don't know when it's going to end. You may say it will end when the president determines the emergency is finished, right? You don't know when that's going to be, but it's temporary because it's only going to exist during this emergency. So I saw specifying expiration date as when do you actually specify a date as opposed to have a temporary rule that doesn't have an specified expiration date. And if I'm misunderstanding that, I'd like somebody to help me out because, I mean, I guess I'd ask IL. I mean, aren't there situations where we have temporary rules but no specified expiration date in terms of identifying a specific date when it will end?
Jen, should I jump in?
Sure, go ahead.
According to our definition, expiration date includes both a specific calendar date and the circumstances of a certain event that will make the rule expire. So we try to encompass both, and this is in the definition that we provide in the beginning of the recommendation thing. Ben is showing now, and the exact language to be used. So it's both a calendar date and upon the occurrence of a future event. So we give that that language at the beginning. I don't have a particular problem with using issue a temporary rule instead in that specific recommendation. I think it works either way, but I do want to address your concern that we try to encompass both, both the option for a specific calendar date or for upon the occurrence of a specific event.
Can I respond back to that? Because I
Yes,
understood that. I understood that, but the question is, should they always be treated the same? That is, when you know a specific date and could put it in there, as opposed to not knowing the specific date, but knowing a specific event that will happen, right? So the question is, should they always be treated the same? Because I thought that, that you might treat them differently depending upon, if you don't know exactly when it's going to end, that might have effects on what you do and how you describe it, as opposed to, and when you know specifically when it's going to end and what you want to be able to tell the people who are subject to the regulation.
I think based on Bill's comment or like potential confusion, I guess I would propose we change it to determining when to issue a temporary rule instead of when to specify an expiration date for a rule, because I don't want that confusion. And then that would mean that we would change the language in paragraph 1 to say an agency should consider issuing a temporary rule. And then circumstances in which it may be appropriate to issue a temporary rule include. Okay, and then I don't know if there's anything on the next page where we would need to make a similar, like, conforming edit.
And Jen,
Yeah,
I think
so in paragraph 2.
Yeah, and this will come up in other paragraphs as well. So I think if the committee determines that it wants to kind of adopt this approach, we can kind of go back through the entirety of the recommendation for the next meeting and make sure all the language conforms.
Okay, Miriam?
Yeah, so there is a difference in terms of how an agency drafts the resulting document in terms of if they know a date or if the date is contingent on some outside event. And if they know a date, then they can actually draft it so that they can choose to have OFR actually remove the regulations from the CFR. If not, then they can still call it a temporary rule, but we cannot remove the regulations, and they cannot have that contingent date in dates in the document. They just have to describe it in the preamble, and they may or may not be able to put it in the reg text.
Okay, that's helpful. Steph Tatham.
Sorry, struggling to find my unmute button. I'm sorry, mine is just a more minor point on 1A. It says a known duration. I think that should just be known and limited, or perhaps just limited.
Limited duration.
Sorry, Steph, did you wanted to say limited duration or instead of
Yeah,
known?
limited duration, or known and limited. But the fact that it's limited seems more important than it being known.
Helena.
Does limited imply a short period? Because sometimes these can be years. Sometimes they're very short periods, but
perhaps finite or specified.
I like specified.
Okay.
I'd be happy to commit it to the committee on style. It's just a minor semantic point.
Okay. So turning back to this issue of whether we should say issuing a temporary rule, as I suggest throughout, consistent with the recommendation from Senior Fellow Michael Hertz. Do I have any objections to that or to that proposal to change that language there? Hearing none, I'm going to view that as unanimous consent to change that to issue a temporary rule and make conforming edits. Okay, so then on Steph Tatham's suggestion of another word for known duration, I think let's send it to the committee of style and we'll look at it next time. Bill?
My question is the language establishes or amends a regulatory framework. I'm not sure, is that language necessary? What about when the rule responds to a condition of limited duration?
That seems like a perfectly fine amendment to me. That's
I didn't know if establishing or amending a regulatory framework had if somebody had some specific thing in mind there, but it just wasn't clear to me why you'd need it.
Do we have unanimous consent to make Bill's suggested edit here? Deem that unanimous consent, okay? Comment from Special Counsel David Pritzker. Sorry, Brigham, did you have a comment on that?
Not in that. I have a comment on 1C.
Okay. This set reverse when an agency.
I don't know if David's on, but I mean, I kind of took the import of his comment to be that we should switch the order of the clauses in the first sentence of paragraph 1. I think that's definitely one of the things he's saying. So instead of
Okay.
saying an agency should consider blah, 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 it should be when an agency determines or reasonably expects that a rule will be necessary for a limited time, it should consider issuing a temporary rule. So that's definitely one thing he suggested. I don't think it changes the meaning of the sentence.
Okay. I have no concern about that. If you guys want to, does anyone have any concern with flipping the order as proposed by Special Counsel David Pritzker? Okay, I take that as unanimous consent. Now, Brigham 1C.
Thank you. This is similar to the prior comment. I'm tripped over the word implement because I don't think agencies implement statutory amendments or judicial decisions. They respond to them. So I would use respond, which has the benefit of being the same verb that we're using in the other subparts.
I think sometimes they implement, but I think response is perfectly fine too, and it matches. So I don't have any concerns with swapping. And does anyone have any concerns with swapping to response? Hearing none, I deem that unanimous consent. Okay, Jeff?
I'm going back to 1A for a second. Is it, I haven't really thought this through, but is it possible that we could have a temporary rule where the agency's response is temporary, but the condition is not of finite or specified duration? I mean, they just have some response that they think will work for a, period, and then is no longer necessary, even though the condition is going to continue.
I think so, but I think that like the point we're focused on here is that that's a particular circumstance in which a temporary rule should issue, like what's in A if they know it's a known duration, but like, C or D might be what you're talking, or C might be kind of some example.
Let's say that there's some health problem that's going to keep persisting for a while, but the agency decides that they want to, do something quickly and in sort of an emergency nature, and just only do it because it's costly, only do it for 6 months. But so the response is temporary, but the condition continues.
Yeah, I'm not sure the way to like phrase that. Like to me, that seems like it's a perfectly fine time to use it, but maybe is unnecessary because this is not like a list of factors that it has to be. It's just circumstances in which it may be appropriate.
Okay. It just occurred to me when I read that there may be some other situations where a temporary rule might be warranted.
Okay, Steph, I saw your hand first.
You could broaden fee by either, taking out the existing language and replacing it with something broader, or adding after or judicial decision or other situation temporarily, and then put some color into the preamble on when that might be appropriate.
Okay, Bill?
That would take care of what I would do too.
Okay, so it sounds like the suggestion is to say responds to a statutory amendment or judicial situation or other situation temporarily.
Yeah.
That helps with my A problem too.
That seems fine to me. Does anyone have objections to the Steph Tatham amendment?
Is that consistent, just that minor stylistic change there too with the committee's intent?
Yeah.
Okay.
Yeah. Don't delete the comma. I can't tell if that's adding the comma or deleting it, but make sure there's a comma there, but otherwise, yeah.
I use the Oxford comma.
Yeah, I love the Oxford comma. Okay, I deem that unanimous consent. So scrolling on, anyone have anything else on A, B, or C? 1A, B, or C? Okay, anyone have anything on 1D? Okay, now was there another that's committee on style, right? Okay, so scrolling
Yeah.
down to 2. I see a comment from Jeff Lubbers. Was that?
Yeah. Yes.
Okay.
I just was a little bit confused by this where it said would help the agency learn from regulatory experience and ensure that the rule remains up to date without requiring an undue expenditure of resources. So I'm not sure that adding an expiration date would help the agency ensure that the rule remains up to date somehow. I mean, that just doesn't quite follow to me. So I think the resources issue is taken care of in 2B. So I think I'd put the period after experience.
Okay, so you would propose deleting everything after regulatory experience.
Yes.
Okay, Steph Tatham, I saw your hand first.
I would support that change, but I think that my support for that is garnered in a broader concern that the way this recommendation, in particular 2B, is written, reads as an endorsement of the Trump administration's experiments with sunset clauses, applying them more generally, specifically, with respect to HHS and more recently with energy actions. And when you look at footnote 9 of the preamble, those actions are referenced as examples of 2B. But the report, I thought, handled this. So yeah, let's take a look at footnote 9 before we move on. So, those are given as an example of the type of action that we're talking about here. But I thought that the report's treatment of this issue was sensitive to the fact that the conference has not, and I've dropped the language in the chat, addressed the question of using sunset clauses as mechanisms to incentivize or mandate agencies to pursue retrospective review. And I think that's right. And I don't think that the report has looked at all of the issues that arise when we use sunset clauses more broadly. I do think it's very resource intensive. And then I think when we say the agency has sufficient resources to conduct retrospective review, that's particularly tenuous given that Congress hasn't passed a full year budget since 1997, and we're on the verge of agency officials being laid off for lack of appropriations. And so I think it's important for the committee to be clear that the conference has not addressed and is not necessarily endorsing that broad use of sunset clauses. So it might require broader amendments than just Jeff's, but I would support Jeff's. And then I would support the inclusion of language in the preamble, much like language in the report, to say that the conference has not addressed and is not addressing the question of whether those are appropriate. And then I think we need to adjust to C, because it does say that those are circumstances when it might be appropriate.
2B, you mean?
2B, sorry. Thanks, Jeff.
So if I can just,
Bill?
just
Sorry,
respond
Bill
to
has
that.
his hand up. So let Bill go first and then we'll go back to you.
Well, I didn't read 2B as being an endorsement of sunset clauses. There's no doubt that some agencies have done that and are more likely to do it in the future for various reasons. I'm against sunset clauses myself, but I didn't read 2B as being an endorsement of it. And I'd support Steph's suggestion for boosting, making more clear in the preamble that we are not endorsing anything in particular or for or against it. But I thought 2B was fine. I thought Jeff's change to main 2 to end at experience was entirely correct.
I agree about B. I mean, with Bill about B. I don't. The conference has in a previous recommendation about retrospective review, basically endorsed the idea, as many executive orders have from various presidents, of retrospective review. But the conference in that recommendation, I forget the number, it did make a big point about the fact that it does take sufficient resources to conduct retrospective review. So that part of 2B is something that the conference has already said. It's consistent. And I think here in adding and take appropriate follow-up rulemaking action is fine too. So, you know, maybe the preamble does need to be tweaked, but I didn't see 2B as taking any kind of a position on the sunset clauses or anything like that. I think so. And you know, my antenna were up a little bit about that, but I didn't see that.
I think that's great
Bill?
if that's.
I wanted to say to Jeff, I think the B goes well beyond the administrative conference's recommendation because it says seeks to commit to retrospective rule by a particular date. And I don't think that the administrative conference said anything about that. That's putting a sunset clause in your rule as opposed to just engaging in retrospective view. But as it is, agencies do that sometimes, and they're more likely to do it in the future. But we're not endorsing it. We're just saying if that happens, this thing is true.
And the resources are important.
So I have two suggestions here. The first is let's first vote on Jeff's suggestion to delete everything after regulatory experience and ensure that the rule remains up to date. That doesn't bother me. Do I have unanimous consent for that change? Seems like this would partially address the concern raised by Steph, is just in 2B, you delete the language by a particular date where you say when the agency seeks to commit to retrospective review of the rule, just delete the language by a particular date. Because then you say it seeks to commit to retrospective review of the rule and has sufficient resources to conduct the retrospective review and take appropriate follow-up rulemaking action. I guess then the question is, we might also want to delete, if any, before the rule expires. Because then we're saying, you know, it's committing itself to retrospective review of the rule in the future, but it's not saying it's going to do it before the rule expires. It's just going to, like, I don't know, that strikes me as perhaps responding, but if that's not responding to your concern, Steph, what do you think?
I think it's helpful, but we still have the circumstances in which it may be appropriate to specify an expiration date for a rule for this purpose in the chapeau clause. So we're saying it might be
that's going to change
appropriate.
to issuing a temporary review.
Okay, which is, I think by definition one in which there is a limited duration. So the rule would be expiring, you know, at some point. So, but I do think, you know, the conference has endorsed retrospective review, and there's some language actually in the same part of the report where I pulled the language from that talks about that. So if there were just a way in the preamble to explain that we're not endorsing the incentivization of pursuing retrospective review through the use of expiration dates, but we are encouraging retrospective review, that might be helpful.
Yeah, so to me, those changes seem like they're headed towards where you're going, because it's like the agency, when it does it, seeks to commit to it, but they're not incentivizing. It's like, okay, this rule's going to expire, so we'll do retrospective review at some point. But if that's not what you were getting at, then we should change it. That's how I understood what you were suggesting. Eyal?
Just maybe to clarify, the report. I think the report I did specify that the ACUS has not recommended that, the conference has not recommended that yet. I do think that I distinguish in the report between a specific sunset clause in a specific rule when the agency has a plan that to basically almost like a pilot program or even for other circumstances to try out a rule for a certain limited amount of time for retrospective review and then to re-examine that at the point of the expiration date. And I separate that type of a specific sunset clause that is a commitment to retrospective review by a specific date to a broader sunset clause that there's just not many cases of, and I don't really have a lot to say, which we have seen with the HHS sunset rule, for example. So I do think these are two different phenomenons, and to be, if Ben and Jeremy might have more to say on the specific language of this recommendation, but at least for the recommendation that I make in the report, I think that I make this point about a specific sunset clause in a specific rule, that it's not a broadly treatment of all rules by a certain agency or a covered regulation, if that makes sense.
Okay. Bill?
It would help me in reading all this stuff as we go by to say, because we're going to change the initial language to an agency should consider whether a temporary rule would help the agency learn. I mean, just keeping that language specifying an expiration for a rule, which we're going to change, it sort of throws me off when I read that. And I have to say, no, that's not what it's going to say. It's going to say whether a temporary rule.
Issuing a temporary rule. I think
whether
it
a
should say
temporary
issuing a temporary rule.
I know just whether a temporary rule would help. Well, I think
Yeah.
the agency learned from it. So it just makes it so I can read it. It helps me to read it when we change it as we go through it. And then
And I do like the edits in 2B. I think that those are helpful. But I think, yeah, to Eyal's point, it would be helpful in the preamble to clarify that what we're talking about in 2B is his recommendation for a more limited retrospective review of a particular rule as opposed to a broad categorical sunset approach to multiple rules.
I guess the question is do we want to be recommending that if they're going to conduct retrospective review, it needs to be done before the rule expires? Because if so, then we want to keep that language. But if not, then the language can go. Although I think we get to it later in the recommendation as well. But like the language contemplates that the best plan is for them to do the retrospective review before the rule expires to avoid confusion for the regulated public.
I think and take appropriate follow-up rulemaking action encompasses that we're trying to avert negative consequences there in terms of the public.
Okay. Bill?
I thought your suggestion that we need, if any, before the rule expires, that you shouldn't be doing this unless you're going to be able to engage in follow-up rulemaking before the rule expires. I mean, it seems like that's the whole point here is you don't want an interim period while the rule is ended, but no rule is followed on if you're intending for it to be a follow-on rule. So I thought, if any, before the rule expires is actually a very important inclusion, and even if we do address the issue later.
Okay, so let's put that text back, but leave the by a particular date out, because then they can that still gives them flexibility as to when they conduct the retrospective review.
I'm sorry to belabor this point, but I think that assumes that the regulation should continue. And, is there a problem in every situation if a rule expires before a follow-on rule comes into place? Like if it's an experimental rule, I don't know that that's inherently a problem, but if the point is we want it done by the time the rule expires, I think that's okay. I don't have a strong objection.
Okay. Do we have unanimous consent to remove the words by a particular date? Okay, I'll take that as unanimous consent. We'll remember to address the sunset clauses more in the preamble. Turning to drafting and publishing a temporary rule. I think we have a comment. Maybe we don't have a comment. Let's see. It looks like there's a comment bubble on drafting.
Sorry, give me 1 second.
Sure.
So we're on 3.
Yes,
so
right
make
before
sure that
3,
we
you see the header.
don't-
There's a comment bubble on drafting, it looks like.
Yeah, I just want to make sure we do the first one because I feel like Amy. Oh yeah, never mind. So I got that. I think the first one is this Michael Hertz one on 3A. But yeah, so I think we're moving to 3.
Okay. Okay, comment from Senior Fellow Michael Hertz. Should 3A and 3B refer to the preamble of both the proposed and final rule? And the suggestion from the staff was including the proposed rule if applicable, which makes sense because a lot of these I take it are issued like without noticing comment because they're like the Coast Guard ones. I think some of those, it sounds like they're not doing notice and comment because it's like very time limited and responding to like immediate concerns. That strikes me as a good suggestion from the staff and Senior Fellow Michael Hertz. Does anyone have comment or objection to that suggestion, including the proposed rule if applicable? David, are you meaning to talk? If not, could you please go on mute? Okay. Hearing no comments, I'm going to say that's unanimous consent to add the text's excellent language. Good suggestion from Ben or Jeremy or Ayal or whoever added that in. And then should that language, I think, Ben, that language should go in B as well, I guess. I mean, there is as applicable, but we should think about whether it needs to go in B because Michael Hertz's comment was for 3A and 3B.
Yeah, I thought about it. I mean, I thought it was sufficient, but if we feel like it's not sufficiently clear, we could add it there too. You know, the preamble, I think, refers back to 3A, but if we want to say the preamble to
How about
proposed or
any
final rule or
how
something
about
like that,
any preamble? Explain in any
Elena,
preamble. What
Elena, did you have a comment?
I was just going to offer that we do at times explain how we will end a temporary rule earlier than planned, because that can sometimes happen. Sometimes if it's an emergency situation where we're guessing how long we need to address it, and so we might add a little more time than we are hoping to need, and so we will explain what we will do to notify the public that it has ended early, but it is less common to say how we will extend it, which is to publish a subsequent rulemaking. That's the manner in which we extend.
Okay, so do you have suggested changes or is that just like a comment on B?
It's just a comment because in response to the comment from Mr. Hertz, I wouldn't think they would know. I mean, sometimes we do, is all I'm trying to say.
Okay, you're responding to the next comment from Hertz, yes.
Yeah.
Okay.
I personally don't think that we need any edit to the text there.
Okay. Brigham?
Thanks. I would suggest will or may, because to that point, we don't always know. And so this seems to sort of recommend that we must commit ourselves to a path. And there's often in these sort of ephemeral temporary situations, there just isn't clarity such that we will commit to a path.
That seems reasonable to me. Do I have unanimous and I think that any suggestion from Bill is a good one. Do we have unanimous consent for those two edits? Okay. Unanimous consent. Thank you. And I think that those changes respond a little bit to that comment. Yeah, I think the May addresses that comment from Michael Hertz. Okay. Moving on. Jeff?
Would it be better to say something other than as applicable, when feasible, something like that?
Well, I think when feasible suggests that like it's always that's always on the cards, and then feasibility is just like whether the agency knows it. But I think part of what the as applicable language is getting at is like sometimes it's just like clearly not applicable. The agency is not does not think that they're going to do anything to extend the rule.
But Michael Hertz's comment is more about, whether it's valuable to say we might do one of these things. So
Yeah.
in some cases, it would be easier for an agency to predict than other cases. But, so I'm not, I guess, applicable wasn't that clear to me when I read it, even as you've explained it.
Okay, Jeremy?
Al or Ben can jump in here, but I think what we meant by this is something as simple as explaining in the document, sort of for accessibility purposes, this is a temporary rule. If we intend to take action such as extend it, amend it, or make it permanent, we will publish a subsequent notice in the Federal Register. Just to clarify for readers the effect of the rule and what additional action, meaning publication in the Federal Register, the agency will take to do something to the rule. Like not predicting the future, just saying here's
that seems more helpful the way you described it.
It sounds like perhaps what we should say is something like where an agency contemplates further action with respect to the rule.
So is that
when
a suggestion to
rather
get rid of
where.
as applicable and replace it
Yeah,
with
I
this?
think that's the suggestion.
When, not where.
When an agency contemplates
Oh.
further action.
Oh, so when, sorry, I heard, couldn't quite hear you, Bill.
Anybody have any concerns with that language? I deem that unanimous consent. And that I think addresses Michael Hertz's comments on that. Then he has another comment coming up on that he would flip 3C and 3D so that the three items that are about the Federal Register notice are clumped together and followed as they are temporally by the item about the CFR. Brigham?
I don't have a comment on the ordering. I have a broader question about these provisions in toto. I can reserve them or I can ask.
Okay, let's hold that for just 1 minute. I don't have a problem. The ordering seems fine to me, but I also think it's perfectly fine the other way. Bill?
I thought it was fine this way, and I thought it was better to leave to the last one, the reference to paragraphs 4 and 5. In other words, after D, you go to 4 and 5. So when D refers to 4 and 5, there isn't going to be something after it like C. In other words, if you switch the order, then you'd be referring to paragraphs 4 and 5, but first you'd be reading another one subsection. So I thought this was the right order.
Okay. Well, he's not here, so I think you win, and we'll just leave that as it is. Brigham?
So I got tripped up over this, and I'd be very curious in Miriam's reaction to this. This feels like a very sort of technical instruction that may be overcome by events in time if the Office of the Federal Register changes its own procedures. And it also feels like something that may be a recommendation for the Office of Federal Register itself about their own processes, rather than sort of homework for the agencies to comply with under an ACUS recommendation they may or may not ever read. So I'm just very curious as to why this isn't something for the Office of the Federal Register or OIRA or somebody to consider the way they deal with their own processes to catch things that are temporary, and whether it might change over time, because this seems particular to a time and place to me. So it's mostly a question of curiosity than an objection.
So the Office of the Federal Register has no authority, no jurisdiction, no experience, and no subject matter expertise to actually read, understand, and interpret the content of any of the regulations that we receive. And frankly, the agencies do not want us to interpret their regulations and decide what they mean and then decide what to do with them based on our interpretation of what they've written. So the only action that we take regarding regulations and putting regulations in or taking regulations out of the CFR is based on the dates section and the literal text of the amendatory instruction. And that's why we have developed very specific meanings of the amendatory terms that we have laid out in the document drafting handbook. So, you know, agencies are required to use those terms and only those terms, because all of those terms have very specific meanings with regard to the action that we take. And then the date section tells us what date to do those actions. And beyond that, looking at the regulatory text, we look at that text for structure, for the codification structure, for the formatting, for cross-referencing, for quotations or no quotations, for basically dotting the I's and crossing the T's. So agencies can put whatever dates they want in the regulatory text itself. That has absolutely no effect on the action that we take, because we do not know what that means. That may mean that that is the date that, you know, the program stops. So no new widgets fall under that program, but any widget that was in process before that date still falls under those regulations. So the regulations may still be in use going forward for the stuff that was in progress or for the stuff that was completed before that expiration date, but no new widgets fall under that. Maybe it means that nothing new falls under it, and anything that was old is not supposed to fall under it and is supposed to use a different program. We have no idea. We can't make that judgment call. Right now, there are like 45 people in this office total, and we publish on behalf of over 300 agencies. We can't make that call. Even if the agencies wanted us to, there's no way that we can understand and then interpret with 3 lawyers sitting here what every single section of the CFR means and then decide what it is that we're supposed to do with it. So
agree.
if an agency
I agree.
thank you. If an agency puts a date in there, they've put a date in there, that's great.
I have a suggestion.
Yes.
I have a suggestion, that is delete the words that are codified in the Code of Federal Regulations. And the reason I do that is twofold. One, it's responsive to Brigham's concern about how does the agency know whether or not it's going to be codified? That all turns on various things at the Office of Federal Register, which the agency may or may not know about. Plus, it eliminates any question about whether or not the Office of Federal Register has anything to say or do about the what's in the text of the regulation. So the point is, if you have an expiration date, put it in the text of the regulations. Now that's one suggestion, and maybe
That
you
sounds
want to
good
take
to
a
me.
vote. Okay, and the next thing is, but what about the situation where comes down to this specify the expiration date, which IL wanted to have it as defined to include not just specifying expiration date, but also specifying, specifying an event that would terminate the thing, and which you may not know the date. And I think that saying specifying the expiration date makes it sound like a specific date. And so therefore, if we want to have it include events that will terminate it, we ought to say that rather than try to define expiration date as also including an event. Is that clear what I'm saying?
Yeah.
There?
So
Okay.
specify the expiration date or the conditional event that triggers the expiration in the text of the
exactly.
regulations.
Right.
So we do have that in footnote 2 of the preamble. We could repeat it or something, but like we have defined it that way in footnote 2 of the preamble of this recommendation, the expiration date.
I understand that, and I certainly don't think it's enough to define it in the preamble. I think you would have to define it in the actual recommendation, because I think it's to bury it in one footnote of the preamble, which people often don't read, and especially because it's defining something in a way that's not actually accurate to the text of what you're defining. So the agent, in other words, it is not specifying an expiration date if you're specifying an event.
Right.
All right.
And in D, if expiration date includes a conditional event that triggers the expiration, that cannot go in the dates caption.
Aha, you see, now we got enough. See, that's why we need to separate these two concepts
Okay.
apart.
Only a date, an actual date, can go in the dates caption.
Okay.
So,
So, I mean,
So first, first I want to go back to Bill's suggestion about the language that are codified in the Code of Federal Regulations, CFR. I don't have a problem with deleting that. Do we have unanimous consent to delete that language? Okay, let's delete that language. Second, I think it's time for a break, just like a brief break, like 5 minutes, and then we will get back into this. So let's all return at 2:54, but you should, grab some coffee or use the restroom or whatever, whatever you need for 5 minutes, and then we will get back to this question. Thank you. Welcome back. Thank you all. Jeff, you had your hand raised before the break.
Yeah, on C, this relates to my comment about the preamble and that part of the preamble that started talking about rules, temporary rules and accompanying regulations, and I found that quite confusing. So C here, I think, is the first time in the recommendation where we mention regulations. And so, I don't know, it's in the text of the rule, I guess, is my question. Why could we just substitute rule there?
So I think we could substitute rule there. I think on the concern raised by Miriam that you can't specify a conditional thing, we could change this and instead of use the defined term of expiration date, which we will put a pin in and need to deal with separately.
Mm-hmm. So I guess
think we could say specify a calendar date of expiration if known in the text of the rule.
Yeah. Okay.
So there's also a difference.
I think, Jennifer, I think you misunderstood what Miriam said. In the text of the regulation, the agency can say anything it wants. It can put the conditional thing in the text of the regulation. You can't put it in the dates caption.
Oh,
Yeah, so just D. You want to say calendar date of expiration.
Yeah, well, but right now we're just dealing with C, all right? And the question is, should we rely on the definition? I mean, first of all, the idea of saying rule, text of the rule. I mean, I think Jeff's absolutely right about that we never talk about regulations. We talk
That's
about
all
rules.
I wanted to say. That's all I wanted to say.
Yeah.
So
okay.
Ask for
and again,
unanimous consent on that.
Well,
okay. So
rule
let's go ahead.
versus
Sorry, go ahead, Miriam.
rule versus regulation. In general, rule is the document that publishes in the Federal Register, and regulation is the part of the rule document that is codified in the CFR. But that distinction has not been adopted universally. So I don't know that there is an overarching view on how to use the two terms. But so
okay,
if you want to use rule in general, that's fine, but the whole rule document itself does not go into the CFR. Only the portion of the regulatory text that is defined is what is codified in the CFR.
But it does say the text of the rule. It would say the text of the rule here. And so that should be pretty clear.
Yeah, just to try to frame the issue, and maybe it's not an issue we can resolve in this meeting, and maybe it's for the second meeting, but I think the question is for the committee is, at what level of generality do we want the recommendations to kind of like express, the rule itself? I think at one level, there's the Federal Register document, which is a rule, if it's a rule. And then the regulations themselves, it's a distinct category. Regulations are codified in the CFR. They are a component of the rule document published in the Federal Register, but they're distinct things. But a regulation is a rule. It's part of the rule, and it is itself a rule. So the value potentially of making the distinction in this recommendation between rules and regulations is that they're two separate things that are published in two separate places, and they serve distinct functions. And in some cases, having an expiration date in a regulation is valuable because people might review the regulation. They might not look at the rule unless they're like a lawyer or something that's researching the history of the regulation. At the same time, you could say, well, we want a higher level of generality. We want to just refer to everything as rules. We don't want to get into this regulation rule distinction. And that might be fine as well, but that's just something to think about.
Bill?
I have to take issue with Ben on that. I mean, the preamble is not a rule, all right? It's part of the rulemaking process. It's part of the record, but the preamble is not the rule. And so here, specifying the expiration date in the text of the rule, I think is absolutely clear what it means. Plus, I want to add, specify the expiration date in the summary and in the text, right? Now, I hope Office of Federal Register doesn't mind that, but the content of what's in the summary. But the idea is that the summary ought to say, this is a temporary rule, and it expires on this date or upon this event. And that should be in the summary easily. It should be in the text of the rule itself. Probably should be in the preamble, but at least I would definitely want it to be in the summary as well as in the text of the regulation.
Elena?
I don't agree with putting it in required or recommending that it go in the summary. Summaries should be 100 words or less, especially for NPRMs, and you don't always have enough words. This is a very practical problem, but it certainly should be in the preamble. It should be in the reg text itself. It should be in the date section, but I don't know that it necessarily needs to specify the expiration date in the summary itself.
Okay. Amy?
I'm gonna second Elena on that. point. I also think it's just a lot of temporary rules are done in emergency situations. And so there's just a lot of room for error and making mistakes. So you might have a typo in the summary then that causes issues. Thanks.
Okay, so I think first let's vote on the suggestion of it changing regulations to rule. Does anyone have an objection to changing regulations to rule here, the text of the rule? Miriam? No? Okay, so that was a vote, or was that or was that an objection?
I mean, that was an objection, but again, that's just the distinction between the rule published in the Federal Register versus what is actually going into FAR.
Okay. Let's go ahead and have a voice vote on this. All in favor of changing regulations to rule, who are committee members, please turn on your microphone and say aye.
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 All opposed, members of the committee, please turn on your microphone and say nay.
Nay.
The ayes have it. Okay. We can also do a voice vote on the proposal to specify the expiration date in the text and summary of the rule. The proposed edition.
I'll withdraw my
You'll
my
withdraw it?
statement on the sub. Yeah.
Okay. Withdrawn. So then we will let's move on. I know we're going to need to deal with this issue of the expiration date, but it comes up also in paragraph 6. And I want to see if we can make some progress on some of the other things and whether it clarifies how we should handle this. So let's move on to paragraph 4.
We haven't dealt with D yet. Have we?
Well, that's the only issue I'm aware of in D is the expiration date issue. Is there another issue in D?
Well, I think that because we know you can't put an event in the date section, all right? It has to be an actual date. I would say provide a specific expiration date if available or if possible.
Okay.
If one is known,
Yeah.
if one is known.
This is where I had suggested a calendar date, if known. Eyal?
That's fine. Calendar date, if known, is fine for me.
Based on my research, I know of several rules. I know there an exemption that OFR is made during COVID, but that included an expiration date that was referring to the health emergency order of HHS, and it used certain language in the date caption. I think it maybe was called application date or something like that. But I think I have one of them in the report. It's in footnote 54. I have like several examples of using an event in the date caption for the consideration of the committee. If that is helpful. I know it was a very particular situation, and it's not a common practice. But that, I think, part of the reason why we base that idea that it might be possible to put it in the date caption.
Okay, that's helpful. Miriam, do you have a response?
Yeah, I mean, as far as I'm aware, COVID is the only time that we have allowed that ever. And that's because it affected basically every single agency had the same problem with calculating the date, and they all had the same trigger for the expiration. So that was an extraordinary circumstance. That was, so basically the rule is we have to have a calendar date. Now, I mean, if we have another global pandemic that affects everybody and we don't know when it will end, or some other catastrophe of that magnitude, then I mean we will probably have to figure something else out. But absent that, we have to have a
Okay,
date.
so we could say something like provide a calendar expiration date if possible or if known. Calendar date of expiration or calendar. We have to say expiration in there to clear.
The if known should go after for the rule. Expiration date for the rule if known.
Okay, yeah. So like in commas after for the rule. Probably.
I just wanted to jump into, so I'll put the if known, it's going to be, you want to do it after
the rule.
And so this sub paragraph is getting into, when an agency does decide to use a specific calendar date to make a rule temporary. So I think in that case, the calendar date would always be known.
What?
Well, the point here is like sometimes we have expiration date. This is like the overarching issue we have to deal with of like, it includes both like calendar date, like January 3rd, and also the date the president declares this emergency over.
Oh, yeah, I guess you're right. Yeah, because it does cover 4 and 5, and 5 covers that. So yeah, I would draw. Sorry.
Okay. Let's move on to paragraph. Actually, well, let's leave that text and not vote on it yet because it may change if we change the expiration date, but like, let's leave it in there for now and go to paragraph 4. I see a comment from Senior Fellow Michael Hertz. Okay, Jeff.
Different point. It's the same point I raised before. Basically, again, this is I raised it in the preamble, but it talks about removing the regulations associated with the rule, and I realize that the Office of Federal Register, has different nomenclature for something that goes into the CFR, but the APA doesn't talk about regulations. So I would just make it to automatically remove the rule from the CFR when it expires. To automatically remove the rule from the CFR when it expires.
Okay.
When it.
Do we have?
I mean, this comes up in other, the next paragraph as well, and throughout the preamble. But I just think it's so confusing to talk about regulations associated with the rule.
Okay, given that we have already voted with a voice vote on rule versus regulations, I would propose that we just ask the committee, the ACUS staff to make corresponding edits throughout any place regulations is mentioned. And I would ask unanimous consent to do that in accordance with the vote we already had. Okay. Now, Bill, I see your hand is up.
Yeah, and it was that this starts off by saying if rule containing expiration date qualifies for, we'd say if a temporary rule qualifies for treatment by the Office of Federal Register as a temporary rule? Or
Yeah,
should we just say
I would put that under the kind of broad instruction from the committee to revise everything like this type of language and just say temporary rule.
I understand that, but I think there's times when we need to focus on what actually we mean. Do we mean the expiration date or do we mean the broad general concept? Here, I think, what about just saying if a rule qualifies for treatment as a temporary rule?
Makes sense.
to delete containing an expiration date. And don't substitute anything else in there.
Okay, Andrew?
Yeah, and I'll apologize up front because if I'm throwing out something that has already been covered, if I got distracted, I just apologize. But what was mentioned in terms of the exemption example and that Miriam explained earlier, but just the idea of exemptions made me curious. Is the intent for this to actually cover exemptions? And I hope not. In terms of in our definition of rule, it's not entirely clear to me. Are we talking about rule meaning rules of general applicability? Because agencies issue exemptions all the time, rules that are sort of like rules of particular applicability. And I just think that would be really, I think, problematic if this was sort of aimed at exemptions, because that's a massive world. So I just want to clarify, this doesn't apply to exemptions. Is that correct?
You mean like waivers and exemptions?
Correct.
I think the answer is sometimes yes and sometimes no, depending on whether they're considered rules or whether they're considered orders. And I think that's true. I mean, sometimes exemptions are relatively generic, and sometimes they're specific as to a particular applicant or a particular person. Particular applicant, it's always considered adjudication and order rather than a rule. But it could be an exemption for a class of things or for a period of time or whatever. So I think the answer is sometimes yes, sometimes no.
So then I guess the question then is, are we talking here about rules of general applicability, or are we talking about rules of general applicability as well as particular?
Goes back to that first footnote,
Right.
And I'd say, if it's a rule, period, right? If in other words, that we have that same problem with exemptions, forget this recommendation, right? But when an agent issues a particular exemption, right, they usually treat it as an order, and they don't publish it in the Federal Register. They don't do lots of things, all right? Because they don't view it as a rule, even though it might be something of a particular effect, because there is this overlap. But if they think it's generic, then they usually think of it as a rule and it would be subject to this. So I don't think the definition is really the issue here. It's what the agency classifies it as, rule or not.
Stephanie, I see your hand is raised.
I have a question on paragraph 4, if this is the appropriate time.
Yes.
So, having had the discussion earlier about the Office of the Federal Register and treatment, I think this is related to the idea that there was a specific track for OFR to treat rules as temporary, which I understand from Miriam is not really a thing. Reading this, it seems to me that it should just be saying if a rule is temporary, it's not treated by OFR as temporary, or am I missing something?
Yeah, I had a similar reaction. My question was almost like if it just is, maybe if the text should just go to, if the agency intends for OFR to automatically remove the rule, then they need to do whatever OFR is going to need for them to do to flag it for OFR. So Miriam, can you help here on what is needed to flag it?
Yeah, so if I think this came from, if the expiration date is more than 3 years away, and then the agency says, but this is temporary, we say, are you sure this is temporary, given it's 3, 4, 5 years away, or in some cases 10 years away? How is that temporary? We will question that, because that seems a really long time for something that's temporary. And we have, like I said earlier, we have stuff that has an expiration date that is not classified as temporary. But if there is an expiration date, whether it's temporary or not, we remove regulations. So, if so I think this was getting to if it's 3 years or less, it's will automatically accept the designation of temporary. And then it has an expiration date, we automatically remove whatever was there from the CFR. But we don't, I mean, it's not an absolute prohibition that you can't have something temporary that's gonna last more than 3 years. We're just gonna make you prove that it is temporary if it's gonna last more than 3 years. But that's the treatment. I mean, that's the special track is we ask about it. Otherwise, we treat it as the same as any other rule.
Okay. Ben, does that resolve your comment? I saw your hand go up and then down.
Yeah. I'd say I'll just leave Miriam's words at that.
I wonder then if this would be better phrased as if the agency intends for OFR to automatically remove the rule from the CFR when it expires, the agency should refer to the rule as temporary and specify its expiration date in the captions of the rule, document published in the Federal Register as required by the Office of Federal Register or as specified by the Office of Federal Register or something like that. And then we don't need the appropriate that confused senior fellow Hertz. And then it can be like keyed to how OFR is specifying where they need as provided for in paragraph 3D. And then I don't know if we need something about OFR or if you think that captures it, Miriam, from the action. If it's in the action in the dates column, it sounds like you're good to go. So maybe we just say delete appropriate and leave it as we have with paragraph 3D.
Yeah, that would work for us.
Okay. Anyone have any objections to that suggestion?
Yeah, I mean, I just want to say that I'm thinking on the fly here, but I mean, I think it's just important to note that, as Miriam was alluding to, that the kind of OFR concept of temporary rule is narrower than the concept of temporary rule in this recommendation. And I think if you remove that language, it doesn't make it as clear, because an agency could choose to have OFR automatically remove the regulations if the rule qualifies, but it might choose not to. But if it doesn't qualify for OFR treatment, then it can't. And so I think removing that might make that distinction less clear, but I'd have to think about it.
Well, I think what, as Miriam has described it, if they have it in the things we've put in 3D, then OFR can remove it. So it's sort of the agency is like within its destiny then to like talk to OFR. I think.
Yeah, I mean, if we get a rule that says it's temporary and it has an expiration date in dates, and the expiration date is less than or equal to 3 years, 3 to 4 years from the date of publication, we're just gonna take it as temporary and edit it as we normally would. If the expiration date is more than 3 to 4 years out, we will probably have a discussion with the agency about why it's really temporary. And that just means that there may or may not be the word temporary in the action line, but not that they don't get to characterize it as temporary throughout the rest of the document.
Okay, so it sounds like that language is okay.
It's okay for OFR.
Okay. Does anyone object to that language? If not, we have unanimous consent for those changes to paragraph 4, and I think we can move on to paragraph 5. Oh, I guess one question before we move on is, are we deleting the word appropriate? It seems like, given that we've said as provided for in paragraph 3D, we could just delete appropriate. So I would be fine with deleting it, consistent with Senior Fellow Hertz's recommendation. Do we have any objection to deleting the word appropriate there? Consider it deleted. Okay, moving on to paragraph 5. Does anyone have any comments on paragraph 5? Aside from, we know we have to put a pin in the expiration date potentially thing, but I think this should say, let's see, the beginning is going to have to be modified.
Is it okay if I just go ahead and make this change to make it easier to read?
Yes.
This is just a COS change.
Yeah. Bill?
I had a question about non-exclusive, the following non-exclusive conditions. I didn't understand what exactly that meant. There are other conditions. However,
Yeah,
the agency should consider referring to the rule as temporary if any of the following non-exclusive, if any. So these, but there may be more.
Yes, that's how I understood it, that these were some circumstances. Steph, I see your hand is raised.
Mine is a different point, so happy to address it now or wait.
Oh, okay. Yeah, that's how I undertook it, how I understood it, that like, if any of the following think they should still consider referring to it as temporary, even if OFR is not going to treat it as temporary, or if they like can't automatically get it removed. And so I thought that was like clarifying that this is not like you have to meet one of these conditions. Do you have a concern with that, Bill, or is that clarification okay with you? You're on mute.
I'm just not sure, what they add. If there's other, however, the agency should consider referring to the rules, such rule as temporary, if it wants to. If these things happen or if something else happens. I mean, if this apply or something else applies. I just didn't know.
Okay.
Do we mean to say, are we saying should do it if it's these things? I mean, that would mean that would be non-exclusive in itself, right? It wouldn't. If it said an agency may consider if any of the following conditions apply, then that would mean exclusive. But if you say should consider if these apply, it certainly wouldn't rule out other things. I thought non-exclusive was unnecessary and, to my mind, confusing.
Jeremy?
I mean, I think what we're trying to say here is when appropriate, including if, colon. I mean, maybe there's a better word than appropriate, like when doing so would improve readability or whatever, but that's the basic idea. Does that help?
that's fine. That's clearer to me.
Okay.
Okay, Elena?
I have a related suggestion. I'm going to try and do this. I think what we're trying to say is the agency should consider referring to as a temporary when certain conditions apply, including. I think it's the non-exclusive that makes it confusing, right? And I'm just trying to, I guess, I think maybe we get it with the when appropriate, including if. Maybe it's getting to what I'm trying to say. I'm trying to, like, talking through it and not writing it out is hard. But something about the order of that sentence is just a little off, and I think that's what's triggering the conversation here.
Okay, maybe we can flag this for the Committee on Style to propose an
I
alternative.
agree, that's a good idea.
Okay, Steph, now you had a separate point.
Yeah, I'm struggling a little bit with C, and I think we could refer that to the Committee on Style as well. And in general, I think it's good to identify rules as temporary when they're temporary, even if they wouldn't be officially designated as such. And I think including this language could make them more searchable and findable. But I'm finding C and everything after, however, really a little bit confusing because I think I don't fully understand the purpose of doing it. And if we could articulate that a little more clearly, probably not here, but in the preamble, would be helpful to me at least.
Yeah, I took it as like, it's helpful for the public to know this rule is temporary. And it may be that like OFR can't treat it as temporary because of the 3-4 year limit on their ability to sort of automatically take them out. But like, there's still value for the public in knowing that these are temporary and that the agency has already sort of specified an end date, which I think is like a valuable thing for the agency to be signaling.
Okay, and then in C, like what fact pattern is this addressing? So the agency doesn't intend to amend the rule to keep it in effect. So that's a case where it does expire and they don't intend to amend it.
Yeah, this is just referring to the case where there are a lot of periodic rules. I guess we haven't, AL talked about a little bit, but rules that are continuously updated. They're temporary in the technical sense of this recommendation, and then that they expire at a specific date, but the agency continuously updates them so that they never go out of effect. So calling them temporary might be confusing or misleading. So that's just what it's trying to reference here.
I think it might be more helpful instead of focusing on what the agency does not intend to focus on what it does intend first. So where, when appropriate, including if the agency intends to update the rule on an annual or other basis, even if it does not intend to amend the rule or something like that. I think just a slightly different construction could make it more clear what is meant here.
Okay, I think Miriam was suggesting that we consider changing the beginning to match what we had done in the paragraph before and just say if the agency does not intend for OFR to automatically so in paragraph 5 and then we would say the rule from the CFR consistent with the previous voted treatment of regulations.
Yeah, my point is in C. I think that's all catching us
Can we
up.
scroll down? And can we scroll down? And I wonder, now that I'm reading it, whether we should say something like, instead of when appropriate, we should say like when doing so provides clarity. include for the regulated public or something like that. For the committee on style, think about that as an option for like why we're suggesting. Because I think that's what we're really getting at here. Okay, and then so C.
I would just say that the agency plans to update the rule on an annual or other periodic basis, comma, and does not intend.
Oh, okay. So the agency plans to update the rule on an annual or other periodic basis.
Yeah, and then maybe we mean through a new rule as opposed to an amendment, or it plans to issue an update to the rule on an annual or other periodic basis, but does not intend.
So sorry, Steph, could you just repeat? Do you want me to just kind of delete all this language here?
Okay. If you could just move that to the end instead of deleting it.
Sorry, this,
Yeah, we're reversing the clauses.
So the agency, did you want language, the agency
intends to issue an updated rule? Or an update to the rule?
To update the rule on a period, whatever, okay.
Yeah.
Update the rule on an annual periodic basis.
But does not intend to amend the rule to keep it in effect, or, yeah. So they might amend the rule if they're updating it on a periodic basis. That's why I find this a little bit confusing.
We might just delete that language. Just say intends to update the rule on an annual periodic basis. Like, I'm not sure what we're getting from that.
That would be helpful. Yeah.
Okay.
Perfect. Okay, thank you.
Okay. So does anyone have any objections to the Steph Tatham amendment to paragraph C? Okay, then I think we have so I see hands from Bill and Jeff. Are those objections or are those other comments?
Other comment.
Well, I don't object to what we just did. I just, on line 120, I think the word any is a little, I think it should just be the rule, the.
Or remove a rule.
Or a. Well, if the agency does not intend to remove the rule from the CFR.
Okay, that's fine. Here.
Instead of any.
Not any, instead of any.
Take out any and put the.
Okay.
Now, that was not my comment. My comment is, what if why wouldn't we want the agency to put the expiration date in the date's caption in all cases? And the answer, I imagine, is, well, maybe they don't want the Office of Federal Register to delete it from the Code of Federal Regulations, which would happen automatically if they put an expiration date in the dates caption. If that's the reason for it, but if you're going to have an expiration date that wouldn't get picked up in the printed CFR because of when it comes out and when the expiration is, all right, you'd still want the expiration date to be in the dates caption. Do you understand what I'm saying? In other words, putting something in the dates caption only triggers the Office of Federal Register automatically deleting it at the expiration date if it would go into the printed Code of Federal Regulations. But there's all sorts of temporary regulations that don't, temporary rules that don't get put into the CFR, don't get put in the CFR because of when they're published, when the expiration date comes, and when the rolling period for putting things in the printed CFR come up. So that's my problem, right? The problem is that we ought to have in the date section the expiration date, I think, in all cases, right? And if the agency doesn't want the Code of the Office of Federal Register to delete the thing automatically, then we should provide something that says that, the agency should communicate directly with the Office of Federal Register to make clear that they don't want it deleted or something like that. But I mean, the idea that something that is supposed to expire in the next 6 months, all right, and which we would hope would actually be put, I mean, hopefully it's going to be in the Federal Register, but that we would want them to read dates. Doesn't say anything about when it's going to expire in the Federal Register. On the ECFR, doesn't say anything about when it's going to expire in the date section. I think that's a real mistake.
It's going to take a lot of explanation in the preamble, Bill.
In the preamble to the regulation?
So
of our recommendation.
Sorry. Okay, just so we need to get order. Sorry.
Yeah.
So Miriam, can you respond?
If it's a temporary rule that is supposed to be for less than 12 months, but it doesn't have an expiration date, it's going in the ECFR and it's going in the CFR. If it has an expiration date, then we treat it as one of the less than 12-month. That's the only way that we know that it's a less than 12-month rule, is if there is an expiration date in dates. Then it does not get picked up generally. Most of the time.
Let me just make clear that, make sure I understand. If the expiration date is less than 12 months from when it's published, it won't be put into the CFR anyway. Printed CFR.
Right, unless it splits the
right.
But only if we know what that expiration date is. So if the agency doesn't put it in, we do not treat it as a short rule. Or as an expiring rule.
But we want the readers of the regulation, or of the rule, to know upfront that this is a temporary rule that expires in a certain date. And the only way to do that, well, not the only way, but the best way of doing that is to put it in the date section.
So in almost all cases for these short rules that you're talking about, agencies put that expiration date in because they know that date. And they don't want them to go into the CFR. So that's not really a concern, having that expiration date not be in dates. It's almost always in dates. I don't know of, I can't think of an instance where they don't put that expiration date in.
But our recommendation here would suggest to them they shouldn't put it in there.
Right. The biggest problem, I mean, there are times when an agency knows what the expiration date is or would be, and they don't put it in because they are assuming or they're presuming that something's going to happen and there's going to be an extension, and they don't want to take the chance that it's going to come out before they do an extension or an update or something like that. So that is definitely a consideration that is a factor when agencies do a temporary rule in terms of when they put an expiration date in to dates or when they just put it into the reg text. The other big problem is when the trigger is an event that hasn't happened yet. And they don't know exactly when it's going to happen. So they can't calculate the date. And they can't tell us when to calculate the date, because we can only calculate a date based on the publication date of the document that we have. So without that calendar date, it can't go into dates. So we can't do anything because we don't know the date. So they know what the event what that trigger will be. They just don't know when that's going to happen. In which case they cannot put that into dates. And there will be no automatic removal because we can't take notice of and figure out when that event is. We have to wait for the agency to tell us that that event has occurred, and therefore, here's the date we're supposed to do something. So it's split. I take your point that the recommendation should be, yes, agencies, if you know what the date is, put it in dates and have OFR remove it. And if you don't know what the date is, but you know what the trigger is, then do this. But only do this if you don't know what the date actually is, if you don't have an actual calendar date.
So I don't know, we're getting close to our deadline, and I have to leave shortly before our deadline because I have a Zoom meeting that I'm hosting starting at 1 my time, 4 o'clock Eastern time. So I'm not exactly sure how to resolve this. I mean, one way would be to delete number 5 altogether, because I'm not exactly sure. You know, I think I understand what it's aimed at, but it seems right now to say, you know, you shouldn't put the date in the date caption, even if you know it, unless you want OFR to automatically remove it. And there won't be automatic removal.
It may
Which
be
would
that
make-
this is mostly captured in that a lot of this is already captured in an earlier recommendation about when the agency should consider doing a temporary rule. Because really what this is getting at is they should still consider calling it temporary in these circumstances, which is not that different from before. So maybe you're right. Maybe removing it doesn't actually change that much content, because we have suggested that they should include the date when the calendar date when they know it. And we've suggested that these same factors, I think, are relevant to considering whether they want to do a temporary rule in the first place. Up in like recommendation number 1.
I mean, I just, at this point, I would bracket this section 5 and ask the staff, you know, if they understand the concerns that I'm expressing, that's suggesting you shouldn't put dates in when actually they should be putting dates in. If there's some way to capture what's supposed to be involved here without giving this negative sense of you shouldn't put dates in when it's going to be a short-term thing, then we could look at it next time. That's my recommendation.
Okay, that sounds fine to me. We'll just consider removal or whether there's something in here that needs to stay. Let's go to section number 6.
So yes, I had a comment on this. I think it's pretty clear on the text to style upon which such a rule has expired. The agency should inform the public that the rule has expired. That makes sense. And I think it's clear.
Miriam, did you have any comment on that?
Yeah, I mean, I would say will expire or has expired. I mean, and there are times when an agency does know, they don't know when the document publishes, but they do know in advance when that event is now going to happen. And so then they can calculate when the rule will expire.
But,
so
but this
that
is more.
They
this
can
is
give
more-
advance notice rather than retroactive notice of expiration.
So that would be an additional point. I mean, I was just trying to address the situation where the rule has expired. And then they should inform the public that it has expired.
Right.
But if you want to add something about if they know when it will expire, they should notify the public about that too. That's fine. That's something that could be drafted in there.
Okay,
Yeah.
so it should say when upon which such a rule will expire or has expired.
Yeah.
Well,
I think that does it. I think that.
yeah. But then you have to
does
change
it.
the next
Is there a
part of
preference on
that, too.
order? Will
That's fine, I
expire?
don't care. The agency should inform the public that the rule has expired.
Or the date that it will
Or-
expire.
Of the count, or of the specific calendar date upon which it will expire.
Should it inform the public of the date that the rule expired or will expire?
Yeah.
Or should inform the public of that date? How about that?
Yeah.
To
Even
inform the
better.
public of that date.
Mm-hmm.
Okay.
Okay, this is down here.
Yeah, just say instead of that language that the rule has expired, you say the agency should inform the public of that date. And when necessary, repeal the rule by publishing the rule.
I'm happy with that.
Okay. Do we have any objections to that language? Okay. Unanimous consent. It's accepted. Let's move on to paragraph 7. Here, I think it should say in the section number of any temporary rule instead of regulation that contains an expiration date.
You want to say temporary rule or just rule?
Temporary rule consistent with and then you delete the part that
Oh,
contains
yeah,
it.
sorry. Yeah, sorry.
Is that citation likely to change when Miriam rewrites the whole 1 CFR?
The 2114.
Yeah.
I don't believe so, but
Okay.
I don't believe so.
Okay.
Pursuant to
Um,
OFR regulations.
Yeah, pursuant to OFR regulations, you could do that. That'd be fine.
Yeah, well, pursuant to ACFR regulations. They're the regulations of the Administrative Committee of the Federal Register, not the OFR.
I think there's a value in specifying which regulation it is. I mean, it may go out of existence at some point, but I think actually identifying the regulation is very helpful to an agency trying to get something out of this recommendation.
And if it does, there is a trail that will tell you how it gets redesignated or where it moves to.
Then I would propose we leave it. Anyone have any objection just leaving it? Okay, let's move on to paragraph 8. Any objections?
I have a question about this.
Okay, Brigham.
I don't know the merit or value of this. I think if there's an agency that does a high volume of temporary rules, they're going to organically develop some kind of like template anyway. So it's either the idea for a template is useless because it won't be used, or their templates are going to emerge in the ordinary course in high volume practices in agencies. I just don't know what 8 is doing.
I think well, when I read it, I thought the point was like It could improve the process with OFR and improve the agency's process. And sometimes agencies aren't thinking about it when they're just like in the midst of temporary regs. And so like having a moment to say, okay, we should have a standardized template for how we do this would serve the agency and would serve OFR and the regulated public by making it more likely that they're consistently doing the things that we are recommending that they should do with their temporary rules.
I'm judging by the vigor of Miriam's nodding that this is in fact a problem that calls for a solution, so I'll withdraw the objection.
Yeah, we have agencies that develop templates that then have significant problems when they come over here that we consistently have to make the same changes to every single document.
So it'd be helpful for OFR too if there was a standardized template. Okay, paragraph 9.
Before we go past 8, I'm sorry, I getting raised hand. I mean, I thought really it might be better to say an agency that probably gets a high volume of temporary rules should consult with OFR in developing a standardized template for drafting such rules. In other words, to make the thrust would not be you should make the template, which Brigham suggests they're going to do anyway, but that they should consult with OFR if they do a high volume period. And I think that would capture both ideas here and be more responsive to Miriam's concern. And whether you adopt that or not, I have to leave now for my other Zoom meeting, so I have to go. Thank you very much. See you on Thursday in 2 weeks.
I think that's a perfectly fine suggestion. Should consult with a OFR in developing
Can we say
a standardized.
about developing a standard?
In developing, because I think should consult with OFR in developing a standardized template for drafting such rules.
Right.
Should in developing. Sorry.
So, well, you would want to say
Yeah,
should consult with OFR, then say in developing, and use that language that you deleted.
All right. Sorry, I misunderstood the edit.
No problem.
That right, basically?
For drafting such rules, not just for
sorry.
Brigham?
I signaled this in the chat, but I, like many others, have been jammed with post 4 p.m. meetings. And I did have a couple thoughts on 9 in addition to 11. I'm just hoping rather than jamming in discussion of 9, we might pause here given the exigency of time.
Okay. Is there, okay, let's see. Is there anything sort of that anyone wanted to raise about 9 that's like a quick solution, like a line edit or anything along those lines that we should talk about with paragraph 9 that's like a smaller concern as opposed to a larger one? I do not hear anything. Okay, so that brings us to 5 minutes to the end of our meeting. So I think it makes sense to put a pin in that. So we have a pin in the issue of the expiration date and where we might flag the calendar issue again in the reg text versus or in the recommendation text. And then we'll have to pick up at 9 when we go on with our next meeting. Apologies, we didn't get there today. There was more in the early stages to discuss than I had expected. But hopefully we can get there. We'll start there when everyone's fresh in 2 weeks. And in the meantime, thank you all for your time. Oh, Steph, sorry, did you have something?
Yeah, I'm sorry. I just had one more comment, which was a request for AL because I had given some language from the report to include in the preamble, but I think we don't have an example of the type of sunset clause that he was referring to being the recommendation in the preamble. So I was just going to request that he provide an example of that for the committee's consideration. Thank you.
Okay. With that, I appreciate everyone's time. I'll talk to the ACUS staff and make sure we have like hopefully address those like committee on style type things before the next one to make it a little bit easier as we go along with the rest of the recommendation and the preamble. And we'll see how we get along. Thank you all for, oh, I'm sorry. I was supposed to give, I forgot on my list. Ben gave me a helpful list of what I was supposed to do as chairing this, and I forgot. I guess I'm supposed to see if there is any member of the public who wishes to comment, and I can ask the committee for their consent if a member of the public wishes to comment. I see a request from Jason. I'm going to assume consent from the committee unless someone jumps up and down. Okay, Jason, you please feel free to comment.
Thanks so much. I'll just say quickly, I'm Jason Schwartz. I'm the legal director of the Institute for Policy Integrity. We're a think tank based at NYU School of Law, and we teach a clinic at the law school, and some of our clinic students, as their assignment this semester, are working on comments on this recommendation. And so please be on the lookout, and please consider the comments from our students. We'll try to submit those before the next meeting. We might have a statement at the next meeting as well. So thanks so much.
Thank you, Jason. The next meeting to consider temporary rules is Thursday, October 9th from 1 to 4 p.m. Eastern time. I look forward to seeing all of you then.